Every single day, we're all making promises, buying things, just living our lives. But did you know that underneath it all, there's this invisible set of rules? A kind of legal blueprint that governs everything from buying a coffee to what happens if someone is just plain careless? Today, we're going to pull back the curtain on this hidden world.
So let's start with a question I bet we've all wondered at some point. Is a pinky promise legally binding? I mean, really? Well, in the eyes of the law, what separates a casual promise you make with a friend from one you could actually get sued over is this fascinating idea called intention to create legal relations. It's the first piece of our puzzle.
Now, to make all of this really hit home, we're going to follow the story of two people. Anya, who's a client needing a new company logo, and Ben, a freelance designer she wants to hire. Their pretty simple project is going to be our guide through this whole maze of promises and agreements. All right, first things first. Not every promise is a contract. Nope. The law has a very specific recipe for what makes an agreement legally stick. And if you miss just one ingredient, the whole thing is basically just an empty promise. So here it is, the recipe. To cook up a simple, binding contract, you need these 4 key ingredients: a clear offer, a definite acceptance, something of value that we call consideration, and of course that all-important intention for the deal to be legally serious. Let's break them down. The offer is the starting pistol. It has to be a clear, definite proposal. It can't be vague. So when Anya emails Ben saying, "I will pay you $500 for a new logo," that's not just a casual chat. That's a formal offer ready and waiting to be accepted.
But here's where it gets really interesting. There's a huge difference between a real offer and something called an invitation to treat. Think about it. A price tag you see in a shop window isn't the shop offering to sell you that item. It's actually inviting you to make them an offer to buy it. It's the difference between saying, "Want to make a deal?" and just saying, "Hey, have a look around." Okay, so acceptance is the moment that deal clicks into place. It has to be a clear, direct yes to the exact terms of the offer. It's like a mirror image. If Ben had replied, "How about $600?" well, that's not acceptance. That's a counteroffer, and it actually kills the original offer dead. But here, his simple "I accept," that's what seals the deal. Now for maybe the most important ingredient, consideration. It sounds fancy, but it just means the value that both sides exchange. It's what makes a contract a two-way street, not a one-way gift. Anya's consideration is the $500. Ben's is his work and skill to design the logo. Both parties have to put some skin in the game for the deal to be real. And why does this matter so much? Because consideration is the bright, shining line between a business deal you can enforce in court and just a casual promise you make to help a friend move their couch. It's also why so many free trials ask for your credit card details. Your agreement to pay after the trial, that's your consideration. That's what locks you in. Okay, so Anya and Ben have a contract. Awesome. But what's actually inside that contract? See, every agreement is made up of different promises or terms, and the law actually treats them differently depending on how important they are. This table breaks it down perfectly. You have a condition, which is a fundamental core part of the deal. It's a deal breaker. If that's broken, the whole contract can be torn up. For Anya, the deadline for her big logo launch is definitely a condition. Then you have a warranty. That's a more minor term. So if Ben delivers the logo in the wrong file format, Anya can sue for any damages that caused, but you can't just cancel the whole project over it. Well, it happens. Life isn't perfect, and sometimes promises get broken. So what happens when one person just doesn't hold up their end of the bargain? And here we go. Ben missed that crucial deadline, and we've already figured out that the deadline was a condition of their contract. So Anya's in a really tough spot, and the law gives her a roadmap for what to do next. This is what's known as a breach of contract. And it's a pretty simple idea, right? You had a deal, and one person, without a good legal reason, just broke their promise. So what are Anya's options? Well, the law offers remedies. The most common one is damages, basically money. Anya could sue Ben for any financial loss she suffered because of the delay. Maybe she had to pay more for a rush job from someone else. And since the deadline was a serious breach, a condition, she also has the right to terminate the contract, just end it and walk away. Now, specific performance, where a court would force Ben to finish, that's super rare and wouldn't really apply here. That's more for unique things, like a one-of-a-kind piece of art. So, we've been deep in this world of promises and deals. But what about when things go wrong between two people who have no agreement whatsoever? Well, the law has rules for that too. This is where we step into a totally different area of law called torts. A tort is basically a civil wrong. It's not a crime, but it can still end you up in court. And the most common one, the one that affects all of us every day, is negligence. Or, as I like to call it, the law of carelessness. Let's completely reset our story. Forget the logo deal. Imagine Ben is now working as a courier. While he's delivering a package to Anya's office, he clumsily knocks over and smashes a really valuable vase. They have no contract between them, so does that mean Ben just gets to say, oops, and walk away? No way. Absolutely not. This is where the tort of negligence kicks in. It's the legal framework that basically says we all have a fundamental responsibility not to cause harm to other people through our own carelessness. And just like our contract recipe, the law has a clear 4-step test for this. To prove negligence, Anya would need to show all 4 things. 1, that Ben owed her a duty of care, which, yeah, he did as someone coming into her office. 2, that he breached that duty by being careless. 3, that his carelessness was the direct cause of the vase breaking. And 4, that she suffered a measurable financial loss or damage. Check all 4 boxes and you've got a case. And this duty of care is such a huge deal. It's like an invisible shield that protects all of us, all the time. It's the reason drivers have to watch for people on the street, it's why stores have to mop up spills, and it's why a courier can't just be reckless and break your stuff. It's a fundamental rule of living in a civilized society. So, from the formal deals we sign to that invisible shield of care we owe each other, these hidden rules are woven into the fabric of our daily lives. So I'll leave you with a final question to think about. Now that you know the recipe, offer, acceptance, consideration, how many truly binding agreements will you make today? The answer might just surprise you.